Let's talk about why they try to force you to quit instead of firing you. If you've ever been in a situation, maybe you had a job before, maybe even now, where your boss is all of a sudden a different person, the whole vibe shifts, your workload doubles, any praises that they have for you now turn into criticisms, and it seems like it happens overnight. Well, you're not crazy. They're trying to make you quit. And there's a reason for that. And there's a legal reason for that specifically. So today I'm going to break down why employers would rather push you out than let you go. Now, I've been practicing law for 25 years, and I have represented hundreds of workers. And let me tell you one thing for sure, with certainty, most employers don't want to fire you. They really don't. They want to make you fire yourself because when you resign, they win in more ways than one. Now, before I go any further, I'll ask you to please remember, if you like my content, to hit the like button. If you've not subscribed, please do so because it goes a long way in helping me continue to bring you content like this. So let's get into it. Now, for starters, if you quit instead of them firing you, it protects them legally. When they fire you, it triggers legal risk. Even though almost all employees are employed at will, which means your employer doesn't have to give you a reason for firing you, if you ever challenge them, though, if you ever go to court and challenge them, guess what? They have to defend themselves by giving you a reason for firing you. They have to document a reason, and that reason can still be challenged, especially if you've recently complained about discrimination, harassment, or retaliation. A firing can lead you to go right to the EEOC or to file a lawsuit after you've been to the EEOC. But if you quit, oh, that makes life so much easier for them. They can claim it was your decision. There can be no wrongful termination if there's been no termination, right? No termination paperwork, no confrontation, no liability. They can spin the story as, oh, she just wasn't happy here. Whatever they want to say. That's why you'll often see employers start doing little sneaky things like changing your schedule without warning. Whatever it is whatever they can do to make your life harder. Excluding you from meetings. Criticizing you for things you used to be praised for. Giving you unrealistic goals. Whatever they can do to set you up to fail. It's all designed to frustrate you into walking out. So they don't have to fire you. They don't have to document a thing. They don't have to explain anything if you leave. Now, a quick note on that, because anytime I talk about this, obviously the term constructive discharge comes up. Let's first of all explain or get on the same page with what constructive discharge means, because I get a lot of comments when I say if there's been no termination, there can be no wrongful termination. So let's talk about that for just a minute. Constructive discharge, just in plain speak, means no person, no employee in their right mind would have continued working under the conditions you were subjected to, and they had every right to quit. So it wasn't really a voluntary resignation. It really was a termination because they left you no choice. You were constructively discharged. That's what that term in a nutshell means. Good luck with that. Winning employment cases is hard enough with the basic standard of proof. But do you know how hard it is to meet that standard? That nobody in their right mind would have remained, no reasonable person would have remained in that job under the circumstances. I mean, that is so subjective. I'm sure some people have forced the company, their employer, to settle with them based on a constructive discharge claim. But I can promise you, those cases are the exceptions rather than the norm. If you are a woman who's been a person who's been subjected to really awful sexual harassment, maybe your boss owns the company and there's no one else to turn to, no one that you can report to, because guess what? He owns the company and you have nowhere to go. Then you understand how a person could say, I couldn't stay there. Would not leave me alone, would not keep his hands off me, and it's his company. What am I going to do? Okay, yes, that is one instance where constructive discharge makes sense, but it's not the norm. Now, a lot of times, it just depends on who your employer is, what their history of litigation is. Some companies will go ahead and settle just to be done with it. Again, that is not the norm. That is the exception. So for all those people who want to go, oh, no, 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 constructive discharge, I won my claim. I have not heard anyone say, I went all the way through court. They always say, I got a settlement, and they call that a win, and it is a win. But if your company, your employer decided to push the issue and not just settle, a judge would probably kick the case out. Because before it can get to a jury, the judge has to review the facts, and he gets to decide, in his opinion, whether or not a reasonable person could have remained in those circumstances. So you are risking a lot when you leave thinking you can assert a constructive discharge claim. I have no reason to misrepresent this. I am telling you what is. So anytime somebody says they won their constructive discharge claim, they're saying that the company went ahead and settled. Now, because again, some companies don't want to get into litigation because it is incredibly expensive, and they'll go ahead and settle. But again, not the norm, that's the exception. Okay. A second reason that your company wants you to quit instead of having them fire you is because it saves them money. Plain and simple. It's that simple. I mean, let's be real. Money drives everything. When you quit, the company avoids paying unemployment benefits. They also avoid potential severance or, like I said a minute ago, wrongful termination claims. Now, here again, I have to pause because as soon as I say they avoid paying unemployment benefits, people go, well, I quit and I still got unemployment. A couple of things about that. Number one, unemployment claims are state by state. So some states might have more lenient rules when it comes to qualifying for unemployment compensation. Others not so much. But what most people do not understand is that when you file for unemployment, the first thing the Department of Labor does is contact your previous employer to confirm that whatever you've written on that paper saying that you are entitled to unemployment benefits is the truth. And if your employer says, no, I fired them for some rule violation or something like that, they will deny your unemployment benefits. Yes, you can appeal and they might change their mind, but if you quit, it's a non-starter. It is, I quit. I just left. Your employer says it to them, and it's an uphill battle for you. If your employer says they resign, see, here's a resignation notice, it will be an uphill battle. So again, are there exceptions to rules? Yes. But if you quit, there's a really great chance that you will not get unemployment benefits. Is it possible? Sure. Is it likely? No. So here's that. In some cases, your resignation even helps their HR metrics. Fewer terminations on record means fewer red flags in company audits or government reporting. They protect their image and you lose your safety net. A third reason they want you to quit as opposed to having them fire you is because it keeps their hands clean. A forced resignation allows your boss to act like their conscience is absolutely clear. They can say, well, we didn't fire them, they left. But behind the scenes, they cheated. They created the conditions that made staying impossible. This is how they defend against constructive discharge claims. Again, legally, when the workplace becomes so intolerable that any reasonable person, anybody in their right mind is what I call it, would feel forced to resign, it's treated like a firing under the law. But proving it is hard, like I mentioned earlier. You need evidence of a pattern. You need evidence of emails, text messages, write-ups, sudden schedule changes, and every time they made your job harder for no legitimate reason. Now, these claims are not impossible to prove, just close enough. That's why I always say document everything. A fourth reason they want you to resign as opposed to having them fire you is because it sends a message to others. When they make you quit, it's not just about you, it's about control. They're sending a warning to everyone else. This is what happens when you challenge us. It's quiet retaliation. And it works because the next person thinking about speaking up remembers how you got treated. And when they remember how you were treated, they decide to stay silent. But here's the truth. When you walk out without a plan, they win twice. They get rid of a problem and they never get held accountable. That's why I always tell my clients, don't quit until you've talked to a lawyer. Here's what you should do instead. If you think they're trying to make you quit, pause. Document every incident. Keep copies of your performance reviews, HR emails, and any schedule changes. If you've complained to HR, if they've changed your pay, save all this information. Anything adverse to you, save all of it. That's your evidence. And here's a strategy most employees don't appreciate. When you stay long enough to collect the evidence, you build your case. You can prove retaliation, harassment, or constructive discharge, maybe. And that's what gives you leverage in settlement or negotiation. And that's the name of the game. That's what it's all about, leverage. So don't let them push you out emotionally. Stay calm, stay smart, and stay. Because quitting might feel like peace in the moment, but legally, it can cost your entire case. Let me tell you something. When prospective clients call me, when employees call me and want me to represent them, they go through my intake process first, where they answer a number of questions. And one of those questions very early in the interview is, why did you leave? And when they say they quit, they resign, I already know how hard it's going to be. So for me, I don't take cases where people quit. If I will read further, if I see something about, like I said, it's a sexual harassment case, and maybe that was why they had to leave. But that is a quick way to lose my interest right off the bat. And that's most employment lawyers. So just so you know that. So again, they want you to quit because it's easier, cleaner, and cheaper for them. But now you know the game. Play it smarter. Document everything and remember, silence is your strategy. Staying is your strategy. If you can, stay long enough to talk to a lawyer, but don't surrender. See you next shift.